And therefore, with a view to ensure that cultural identity, my lord, this provision is made. But, my lord, it is so egregious, my lord.
It doesn't appear to be correct, in fact. Islam is Islam. Traditions, they may have different, but
Yes.
religion will remain the same.
The purpose is, my lord, why not all scheduled tribes? Scheduled tribes classified under the constitution as requiring separate protection. My lord, I can assure.
Your argument, as you have argued and you have projected, that someone had by fraud or maybe misreading or misrepresentation taken a land from the tribal and had created a waqf. Therefore, the mere existence of the waqf is through an illegal means. If that is void, the whole thing goes. So there is no need for such a protection. That in itself will go.
Lord, question is, Lord, would that be a ground enough? There would be arguments and counter arguments. My lord, I may read judgments. My lord, let me read judgments. My lord, if your lordships are prima facie, my lord, satisfied, that I'm only, my lord, suggesting that would that be a ground enough to stay a statutory enactment? Particularly when I'm repeatedly saying that I am never given an opportunity to file a reply to this. I could have filed, my lord, statistics, reasons, figures, etc., but it was identified at 3 and the court said you filed a reply within a week. Please come to, my lord, my note. I'll just, my lord, show the what the Supreme Court has said about scheduled tribe areas in schedule. Classification is not, my lord, religion based. Please kindly see the provision first. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes, not all scheduled, I have quoted in my note. The first page quotes, for your lordship's ready reference. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th schedule or 6th schedule to the Constitution shall be declared or deemed to be Waqf property. Lord, this does not take away their right to dispose of the property. Even if they want to do charity, they can always create a trust. That is what, my lord, proviso to section 2 now provides, that if you don't wish to create a waqf, you create a trust. Now, my lord, please see how, my lord, the Supreme Court has dealt with this proposition. My lord, the second page of this note, my lord. And I'll read, my lord, only the highlighted part. This is 2004, volume 10, SCC 65. Your lordship gets, my lord? My lord, the Chief Justice gets, my lord? The Constitution of India and the laws made thereunder treat tribals and tribal areas separately wherever needed. The tribals need to be settled, need to be taken care of by the protective arm of law and be saved from falling prey to unscrupulous device so that they may prosper and by an evolutionary process join the mainstream of the society. The process would be slow, yet it has to be initiated and kept moving. The object sought to be achieved by 1950 Act and 1956 regulations is to see that a member of an aboriginal tribe indefatigably continues to own the property which he acquires, and every process known to law by which title in immovable property is extinguished in one person to vest in another person should remain so confined in its operation in relation to tribals that the immovable property of one tribal may come to vest in another tribal, but the title of the so and so. Lord, kindly see the next judgment, my lord. In P. Rama Reddy versus State of Andhra Pradesh, this honorable court was considering the constitutional validity of a law made by legislature of Andhra Pradesh. Transfer of property, Lord, then this is the section which is quoted, and please come to para 12 of the judgment. What has emerged from the additional counter affidavit, I may skip that, my lord. Kindly come to the next page, my lord. Para 14. It cannot therefore be gainsaid that the tribals not only require to be preserved and protected in respect of their economic and educational interest, but they also require to be immunized from social justice and exploitation. the founding fathers of the Constitution of India have in their wisdom and foresight taken cognizance of this vital aspect, as is evidenced by the provisions of Article 15.4. 15.4 is nothing in this article shall prevent the state from making any special provision for the advancement of socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. Under Article 46, promotion of educational and economic interest of scheduled caste, scheduled tribes and other weaker sections, the state shall promote with special care, etc. Then number 15, the constitutional mandate reflected in the aforesaid articles has influenced this court in no small measures in upholding the constitutionality of the impugned legislative provisions enacted with an eye on preserving and protecting the interest of tribals in the lands in the tribal areas. Lord, I'm another, my Lord, way of assisting your Lordship is this. After final hearing, if your Lordship, my Lord, still come to the conclusion that this may not muster your Lordship scrutiny under Article 14 or whatever, your Lordships can strike down that provision, and thereafter it would be open for them to create a Waqf. Lord, I am posing a question to myself. It is so egregiously or, my Lord, so my Lord, arbitrarily ex facie illegal and unconstitutional, not only illegal, Lord, that it needs to be stayed today. Lord, next judgment, para 7, Lord, so-and-so versus State of Karnataka. The prohibition from alienation is to effectuate the constitutional policy of economic empowerment under Article 14, 21, 38, 39, and 46, read with preamble of the Constitution. Accordingly, it was held that refusal to permit alienation is to effectuate the constitutional policy. The alienation was declared to be void under Section 23 of the Contract Act, being violative of constitutional scheme of economic empowerment to accord equality of status, dignity of persons, and economic empowerment. Now, my lords may kindly see, under the scheme of the Constitution, the scheduled tribes as a class require special protection against the exploitation. The very existence of scheduled tribes as a distinctive class and the preservation of their culture and way of life based as it is upon agriculture, which is inextricably linked with ownership of land, require preventing an invasion upon their lands. The Impugned Act and similar measures undertaken by the different states placing restrictions on transfer of lands by members of scheduled caste and scheduled tribes are aimed at the state policy enshrined in Article 46 of the Constitution, which enjoins that the state shall promote with special care the educational and economic interest of weaker sections of the people, and in particular of the scheduled caste and tribes, and shall protect them from social injustice and all forms of exploitation. One has only to look at the artlessness, the total lack of guile, the ignorance and the innocence of helplessness, the economic and educational backwardness of the tribals, pitted against the artful, usurious, greedy land grabber and exploiter invading the tribal area from outside, to realize the urgency of the need for special protection for tribals if they are to survive and to enjoy the benefits of belonging to sovereign, socialist, secular, democratic republic. My lord, kindly appreciate if there is a state restriction, and there are many states where there is a restriction.
Maharashtra also is there.
Maharashtra has, Gujarat has, but all are upheld by the court.
One of the cases is from Maharashtra only.
Yes. Now, my lord, kindly appreciate, I am appealing to your lordship's conscience. I am unable to go and purchase the land of the tribal because the state law prohibits. I go there, ask him to create a Waqf, and I become the mutawalli and do whatever I want to do with the land, my lord, in question. This can be, my lord, a misuse. I'm aware, my lord, a possibility of misuse cannot be a ground for challenge, but cannot be a ground, my lord, can be a ground for upholding that this is the mischief which the statute seeks to protect. And ultimately, your lordships can always strike it down. My lord, please, my lord, bear in mind while reading every section, whether this section is so atrociously unconstitutional on the first blush that it needs to be stayed. That's, my lord, my limited purpose, my lord, right now. Then kindly come to, my lord, next 104. Application of Act. My lord, this is deleted and the deletion is challenged. My lord, section 104. My lord, your lordship would find in my note. My lord, I'm sorry, it's not paginated.
This very.
Para 11. Para 11. Well, just for your lordship's ready reference, yesterday, my lord, I was taking your lordships to two different documents, my lord. I don't wish to do that today. My lord, no.
Yes.
My lord, 104. Application of Act to properties given or donated by persons not professing Islam for support of certain Waqf. Lord, I need not read. Non-Muslims were permitted to create a Waqf. Lord, that happened by way of an amendment in 2013, as I pointed out on yesterday. In November 2013, this was brought in. Now, please recollect the statement of objects and reasons of 1923 Act, where in 1923 in detail they said that this is being used to defraud the creditors. I am a Hindu. I know Waqf is an Islamic concept. By virtue of 104, I would create a Waqf on my property. My learned senior, my lord, who is supposed to recover money from me and who has a decree in his favor against me, cannot execute the decree the moment I make a Waqf of my property. But the JPC has given a very plausible and very, very convincing ground. Look, kindly mark this. This does not deprive a non-Muslim to donate for any Waqf. So creating a Waqf is different from donating to a Waqf. Lord, please see what the Joint Parliamentary Committee says at the foot. Lord, it ultimately says, my lord, I'm not reading. And this is why, my lord, 5 years. This is why 5 years. That if you are a if you were to show that I am a Muslim, how is it is to be shown, I'll show. And for 5 years, so that you don't use this device of Waqf for the purpose of defrauding anyone. And that is the menace, my lord, accepted 102 years back, and that menace continues. But now, my lord, I am a Hindu. I cannot create a Waqf because 104 is deleted, but I still want to donate. Well, I can still donate. Please see section 72. That is what the JPC says, that if you really have a faith in a particular Waqf, then donate it. Would your lordship see section 72, 1, Roman 5, F? My Lord Justice Masi, my lord, Act may be taken, or possibly it's at page 60, my lord, possibly we have the same edition, page 60.
Yes.
My lord, this is regarding annual contribution payable by the Waqf and what should be the income. But I'm not reading the whole, it's a very long section, but please see Roman 5. Your lordship gets, my lord, the Chief Justice gets.
Yes, sale proceeds.
Sale proceeds of immovable properties or rights relating to or arising out of immovable properties, if such proceeds are reinvested to earn income, provided that following items of receipts shall not be deemed to be income for the purpose of this section. Please see F. Donations in cash or kind or offerings made by the donors as contribution to the corpus of the Waqf. I am a Hindu, I am a non-Muslim, I can donate to the Waqf. I cannot create a Waqf. Well, that's the only limited thing, my lord, which has happened.
It means that no immovable property can be donated, absolutely.
It can be donated also.
No, but how will it cover here? It only says with regard to cash or kind.
donations in cash or kind,
or offerings.
or then it becomes a waqf. My lord, how, my lord, can anyone object to a provision that waqf, which is an Islamic concept, though not an essential religious practice, should mandatorily be permitted to non-Muslims also?
No, it can't be mandatory. It can always be voluntary.
My lord, if I am a,
It can only be voluntary.
my lord, I am a Hindu, my lord, I am a Hindu.
2013 when this was brought,
Pardon?
what is the SOR of the 2013 Amendment Act, which brings this 104?
No, 104 was in 95 also.
95, no, the footnote says that it is brought in 2013.
Just let me check up. Lord, yes, Lord, I'm sorry. Lord, kindly see 95.
Of course. It was brought in 2013 and removed in 2025 now.
Yes, Lord, because 2013 up to 1923 till 2013. My Lord Justice Masih, my Lord, just listen to me, Lord. Up to from 1923 till 2013, the qualification was any Muslim can create a waqf. In 2013, any Muslim was deleted and any person was substituted in 13 after 90 years. Lord, that is now done away with. That it has to be by Muslim. If I am a Hindu,
All through it was limited to one religion.
yes, and
A person professing Islam.
correct, my Lord. My Lord, kindly see. Lord, if I am a Hindu, I really want to create a waqf, which is now not permissible. I'll create a trust, my Lord, for the same function. Lord, can I not, as a Hindu, create a mosque and run it as a public charitable trust? It's not that the charity is prohibited. Charity of a particular kind is prohibited. Now, my Lord, kindly see the next provision.
You were yesterday saying that some provision which was introduced in 1995 was deleted in 2013.
Yes, so 2013 also, yes. Section 87, my Lord, for example, was deleted. And Section 36, my Lord, was amended that from 2023, 90 years, Muslim can create a waqf. In 2013, only person were deleted and any person came. Now, 95 brought, the Lordships would recall the 3-member committee.
Yes.
Sayyid Ahmad.
76.
They said that
Not to interrupt, 2010, there's a judgment of this court saying that a non-Muslim can create a trust. That's why 2013 amendment came. 2010, there's a judgment of this court by Justice Singhvi saying that a non-Muslims can create a trust. Anyway, I don't want to.
Lord, I don't wish to go into it. There is also, my Lord, a provision which is taken care of. But ultimately, my Lord, your Lordships would examine whether that needs to be stayed right. When he has another remedy, a Hindu who wants to really create a mosque, he can create a mosque and run it as a public charitable trust. Why should he create a waqf only? My Lord, 87 was deleted. Apropos, my Lord, Don. So if he is to defraud the creditor. Lord, apropos, my lord, the Chief Justice's query, your lordships would recall in 1976, the committee was appointed, 3-member committee.
Their malpractice and all that.
Yes, my lord. And they say that there is a rampant mischief by creating Waqf and not getting it registered. We must do something harsh. So they suggested an amendment that you provide for a statutory mechanism that if you are not registered, you can go to the court of law. Parliament in 1984 passed that act.
But it was not,
It was not implemented,
it was not notified.
notified. Now in 95, that came as section 87. Just to ensure that only registered, that mischief which was pointed out by Syed Ahmad committee is remedied. And he was very harsh, my lord, in use of the language in report. Page 53 is that provision, section 87 of my reply.
Yes.
Lord, this was deleted in 2013.
Page?
Lord, 53 of my reply. Page 53 of my reply. My lord, this came in 1995, but surprisingly deleted in 2013, November 2013. Right. And I must, my lord, add here, I mentioned it yesterday, this kind of provision that unregistered trusts or entities will not be able to litigate is found in all trust laws, whether private trust or a public charitable trust. This is not something novel for Waqf, but deleted. Yes. Now, my lord, another
Copy paste of which?
section 31 of Bombay Public Trust Act. Lord, page 35 of the counter, the committee itself records, the Syed Ahmad committee. Page 35, my lord, if your lordships can have only, my lord, for a second, of my counter, my lord. I have quoted, my lord, page 35 of my counter, the committee's report, committee headed by, my lord, Syed Ahmad.
Page 30.
Somewhere in the let me read, my lord. Deliberate concealing of Waqf and willful failure to have them registered is a deeply prevalent malady affecting the administration of Waqf. Attaching highest importance of this matter, we have separately provided for imprisonment, etc. Please come. We consider that in the implementation of this policy, we have a very
You already read that.
Yes. So this was taken from Lord and every trust act has this provision. There is nothing wrong about this. Now, my lord, next, which was under attack was Limitation Act. Earlier, Limitation Act was not applicable.
My volume, counter affidavit, it should be here.
either for the trust or against the trust. So it worked both ways,
Till 2025.
25. So we said now Limitation Act would apply. So if I have to file a suit against the trust, against the Waqf, I'll also have to go by the Limitation Act. And if Waqf wants to file some proceedings against me, say for my eviction, suppose I'm an unauthorized encroacher in the Waqf property, they will also have to file, my lord, within limitation period. The question is, my lord, when Limitation Act is made applicable, which is applicable to rest of the country, Lord, I'm posing a question to myself, would it be a, Lord, good enough ground to stay it at this stage? I leave it at that, Lord, there's nothing more. Then 107, I'm sorry, 108. Lord, 108 is Evacuee property. Lord, my lord, my preliminary problem and the preliminary objection is this. Lord, we are, so many words. Lord, we are arguing on academic challenges. My lord, what is Evacuee property? My lords are aware. During, at the time of independence, when partition took place,
Regarding tribals also, your argument is the same.
Yes.
That none of the tribals has come to the court.
yes, but not to my knowledge, but maybe they may have chosen one or two tribals.
It is a tribal area.
It's the entirety is not, fortunately. Anyway, my lord, it's for their protection. If one person does not like it, he doesn't represent entire tribal community in the world. My lord. My lord, kindly see the difficulty.
Sorry, your lordship has asked a question. I don't wish to interrupt.
But you are
My
still
opinion-
doing it.
No, my lord asked a question.
But not to you.
Very well, I'll say.
Anyway.
We asked whether there is any.
No, anyway, I was just joking, my lord. We always do that. I don't want to interrupt, but then we end up.
Get back to the old Ahmedabad days.
Yes.
My lord, there are petitions from tribal areas espousing this particular cause. That's the simple answer. So, my lords, my learned friend may not be correctly instructed when he says that there are no such petitions.
Lord, I must tell your lordships now, Lord, I didn't want to say this. There are petitions by tribal organizations defending this provision that we are being victimized.
I am representing one of them.
Yes,
Yes.
that we are being victimized, our lands are being grabbed under the garb of Waqf. Therefore, my lord, I am respectfully urging that there is view and a counter view,
Yes.
but it is not so, my lord, atrociously unconstitutional.
No, agree with that.
That it has to be stayed here and now.
What is that?
Yes. Lord, another last, my lord, was the Evacuee property. Lord, Evacuee property. Evacuee property is a property which was left in India when people fled to Pakistan. Correct, my lords? Those properties prior to, my lord, that partition, which were Waqf, were entrusted to the officer under the Evacuee Property Act. He is called custodian or something. Custodian. Lord, that Evacuee Property Act itself is repealed now. So corresponding provision is repealed, my lord. But we do, at least to my knowledge, there is nobody who is here saying that this was my Evacuee property, because of deletion I am facing this problem. Otherwise, I can deal with that. Which is that Evacuee property? Where is it situated? What is your problem? What were the difficulties faced by you?
Your half an hour is.
My lord, it's over, my lord, and my arguments are also over. Give me only 5 minutes. Lord, I don't, Lord, only one thing. Lord, kindly take Sharia Act. Lord, on the argument, I don't wish to enter into this argument for the simple reason. Now, earlier, my lord, from 2023, a person has to be Muslim. Nobody objected to it till 2013. Now it says person has to be Muslim practicing for 5 years. I have given the rationale. They can wait, my lord, if they, or they can prove. The rules will come. And maybe, my lord, it would be that you give a declaration before some authorized person that I am practicing Islam, etc. But please have a look, my lord. If I want to use Sharia Act and be governed by the personal law, I have to prove that I am Muslim. My lord, we don't have, my lord, any other personal law because they are codified for other religions. But for this, please see section 3, Sharia Act. Sharia Act is applicable as a personal law to all Muslims. Please see section 2. Section 2, personal law of marriage, dissolution of marriage, talaq, ila, zihar, lian, khula, mubarat, maintenance, dawah, so and so, so and so. In cases where the parties are Muslims, shall be Muslim personal law, Sharia. Your Lordship gets my last name. Now please see 3. Any person who satisfies the prescribed authority that he is a Muslim and that he is competent to contract within the meaning of section 11, that he is a resident in territory so and so, may by declaration in the prescribed form and filed before the prescribed authority declare that he desires to obtain the benefit of provisions of this section, and thereafter the provisions of section 2 shall apply to the declarant. Lord, if as a Muslim I have to go to a prescribed authority for getting benefit of personal law in case of marriage, divorce, etc., etc. So the same thing is for Waqf, which was there, my lord, since 1923. Now only additional condition is 5 years. 5 years because you don't defeat somebody's rightful claims by creating a Waqf. Lord, my last submission, my lord. As I have said, my lord, I have many judgments, my lord, on the question whether it is an essential religious practice or not. But that being a pure constitutional question, I have cited some judgments, my lord. Lord, I have Shirur Mat, I have Tilkayat Ji, my lord. There are a large number of 5 judge and 7 judgment judgments. But I'm not, my lord, citing it right now. Last point, Lord, there are some petitions. There were some petitions. I'm making my position clear. I don't represent them. Where they have challenged the main act, 95 Act. What is under challenge is the amendment to 95.
Hari Vishnu Jain,
No, there are several.
Vishnu Shankar Jain.
Vishnu Shankar Ji. But there are several petitions. Lord,
I mean, in 2025, they want us to take the provisions of 1995.
I'm saying something different. I'm not supporting them. I'm neither opposing them. I'm not supporting them. I'm saying something totally different. Lord, their argument was,
We will not listen to.
no. I'm not on the stage.
We are not going to entertain any petition in 2025 challenging
Allow me to
1995.
allow me to come. I'm saying something totally different.
Yes.
Their argument was that since we were sent to High Court, these people also should be sent to High Court. I am not raising that plea. It is a question of law. It is a constitutional question. I am not raising that plea. Please hear the matter under 32. That was I was saying. I was not supporting them. It was their case that if we were sent to High Court, send them also to High Court. I'm saying, please hear it. But
One bench having handed in the matter, how can we even hear that?
absolutely. But I'm not raising that. I'm making it clear that I'm not raising it. And Lord, therefore, your lordships may hear it at any date of your lordship's convenience. But Lord, rarest of the rare thing, my lord, they have not crossed the threshold, my lord. Last, Lord, frequently without reading Ram Janmabhoomi judgment, my lord, they have said that Waqf by usury is accepted. Lord, the entire judgment says that under the act as it existed, it's a 2019 judgment, 2019 or 20 judgment, that As it existed, Waqf by user was there in the Act. So they say Waqf by user is a recognized concept. But I am also not disputing Waqf by user was a recognized concept. It is now deleted. So it never said that it was an essential religious practice or something. They said Waqf by user is an accepted practice. It was an accepted practice. It was statutorily recognized practice. And statutorily recognized practice can be statutorily taken away. Now, my lord, if your lordships were to stay that, something which is taken away by operation of law will, by an interim order, come back, but which your lordships would not do. So that's my respectful submission.
Thank you.
But grateful for a very patient hearing.
Lords, may I have the indulgence, Lords, to submit on behalf of State of Rajasthan, Lords. I'm sorry.